Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline lawyer. We have described already that you are practicing law whenever you select forms to use and then complete those forms for two third parties in a real estate transaction. So basically, every time you act as a real estate broker to select forms and complete those forms, you are engaged in the practice of law. And you are authorized to do so long as you fit within the authority, the scope of authority provided by the Washington State Supreme Court in the 1985 Colton versus Heritage House decision. What I want to talk about in this video is form selection. Because it's pretty easy to say, well, you know, I use the statewide form system, or I use the forms that are provided to me by my brokerage firm. So clearly I'm using forms that I'm allowed to use. Form selection is solved. But it's not. Think about the number of forms in the statewide form system. Think just about the purchase and sale agreements themselves. There's a purchase and sale agreement for improved residential real property. There's a purchase and sale agreement for unimproved residential real property. For mobile and manufactured homes, in a park or not in a park. For condominiums. Now, here's a pretty common problem that brokers encounter. Broker is selling a personal property mobile home in a park. If the brokers use Form 21 in that scenario, they are creating a contract where seller is obligated to give the buyer a warranty deed to real estate. Is seller conveying title to real estate to the buyer in this transaction? No. Seller is conveying a personal property mobile home on leased land. There are forms to use for that transaction, but if those brokers use Form 21, they are creating a transaction that cannot be performed. Seller has no title to convey to the buyer. Seller cannot deliver a warranty deed to buyer for real estate in that transaction. What if the parties use a Form 21 when the transaction involves a condominium? Same problem. Real estate will not be properly described within the boilerplate language of the purchase and sale agreement if you use a Form 21 when the transaction involves a condominium. What if the two brokers have a pending home sale contingency transaction with a Form 22B, and after the buyer sells their home, the brokers insert a 22Q, the pending sale contingency in that transaction? That's an improper use of the forms. You have selected the wrong form to use, and you have created a conflict in the terms of agreement because we now have two different closing dates in this transaction based on your misuse of the forms. What if you're the listing broker and your seller has given a Form 22A, Paragraph 2, Option A financing contingency to the buyer, and you fail to use the 22AR notice to perform by failing to bring it to your seller's attention, so your seller never has the opportunity to force the buyer to waive their financing contingency, a right that the seller negotiated for based on the buyer's offer to purchase seller's property. We could go on and on all day about which form you should or shouldn't be using. What if you allow seller to retain possession of buyer's property after closing and you don't create a rental agreement for that possession? Form 65B is provided for that purpose. What if you allow buyer to move in and you don't create a rental agreement for buyer's occupancy of seller's property? Form 65A exists for that purpose. What if you're representing a buyer who is relying on a contingent source of funds and you fail to use Form 22EF or some other form to identify buyer's reliance on a contingent source of funds, notwithstanding buyer's representation in Form 21 Paragraph A that buyer is not relying on a contingent source of funds unless otherwise noted? Now, if you're hearing this information and again, you've got that my head's about to explode feeling, like, how on earth are we supposed to keep all of this straight? Well, then you need to learn the basics of the statewide form system. I suspect many of you hear this information and you go, yep, I knew that. Yep, I knew that. I know that I can't use this form with that form, or I know that I have to use this form when I have this happening. If you don't know that, you've got to learn that. You have to know the statewide form system enough to know what all of the different forms do, when you need to use them, when you must avoid using them, when using one would create a conflict with another, etc., etc. You cannot competently draft a purchase and sale agreement for your client and the other party in the transaction unless you know the forms in the statewide form system. And the tenet of law that supports that statement comes from the 1985 Colton versus Heritage House case, where the court identifies that it is the practice of law when you select the form to use. Make sure you understand the statewide form system enough to know that you are selecting the proper form in the proper time for your client to use. If you have questions on this topic or any other, ask me a question by visiting warealtor.org. Thank you for being a Washington REALTORS member.